Welcome to the Adult Foster Care Division's training video on required resident forms, documentation, and records in adult foster care homes. We hope you find this information helpful. Let's get started. AFC facilities are approved by the division to serve at least one program type. Aged, Alzheimer's, developmentally disabled, mentally impaired, physically handicapped and traumatically brain injured are some of the program types available in AFC facilities. When admitting new residents into a facility, licensees are responsible for ensuring that the kinds of services required to meet the resident's needs are available in the facility, as well as ensuring the resident is compatible with other residents. Adult foster care administrative licensing rules require specific resident forms and documentation be completed, and certain resident records be obtained and maintained in the facility. The department provides templates for several required forms, or the licensee may decide to utilize their own forms. Let's explore these resident forms, documentation, and required records in greater detail. The first required form we will discuss is the Resident Healthcare Appraisal. The healthcare appraisal is a written statement by a licensed physician, licensed physician's assistant, or registered nurse that provides an assessment of the general physical condition of a resident. At the time of a resident's admission, licensees are to obtain a written healthcare appraisal for the new resident. A medical discharge summary by an appropriate healthcare professional is also acceptable. Healthcare appraisals must be completed within 90 days before a resident's admission. If a written healthcare appraisal is not available at the time of a resident's admission, licensees will have 30 days to obtain the appraisal. Licensees are to obtain an annual healthcare appraisal for each resident thereafter. During inspections and/or investigations, licensing consultants will review the date of a resident's admission and compare it to the date of the initial healthcare appraisal or medical discharge summary, to determine compliance with time requirements. The next mandatory form we will discuss is the Resident Assessment Plan. An assessment plan is a written plan that is prepared in cooperation with a responsible agency or individual that identifies the specific care and ongoing support, services, and activities appropriate for a resident's physical and behavioral needs and well-being, as well as the methods of providing the care and services, while considering the preferences and competency of the resident. According to rule ending in 685, sub-rule 2, a licensee shall not accept or care for a resident until a written assessment has been completed. A written assessment plan must include all of the following: the amount of personal care, supervision, and protection required by the resident that is available at the facility, the services, skills, and physical accommodations required by the resident that are available at the facility, and verification the resident is compatible with other residents, their assigned roommate, and members of the household. Licensees are not required to use the department's form for a written assessment plan and may choose to use their own form. Regardless of format, assessment plans must address and contain all the components identified in the division's definition of an assessment plan. In addition to conducting an assessment plan upon a resident's admission, written assessment plans must be completed with, and signed by, the resident, or the resident's designated representative, responsible agency if applicable, and the licensee, annually thereafter. For emergency admissions, licensees have up to 7 days to complete an assessment plan following a resident's admission. That being said, it is always best to do a written assessment plan prior to agreeing to accept a resident into your facility. Licensees should ask the question, is this really an emergency, and if so, can I at least complete the assessment plan to ensure the resident's safety and the safety of others? Assessment plans may be completed by someone other than the licensee or licensee designee. However, by signing and dating the written assessment plan, the licensee or licensee designee has acknowledged that all rule elements regarding resident admission have been met, and the assessment has therefore been completed. Let's take a look at a few adult foster care licensing rules that include the Resident Assessment Plan and Healthcare Appraisal. Residents of different gender identities shall not occupy the same bedroom for sleeping purposes unless agreed to by both residents, designated representatives, or responsible agencies and documented in each resident's assessment plan. Staffing shall be sufficient to meet the needs of the residents in accordance with each resident's assessment plan and individual plan of service. A licensee shall provide supervision, protection, and personal care as specified in a resident's assessment plan. A hospice service plan, do not resuscitate order, or any other advance directive must be included as an addendum to the resident assessment and maintained with the assessment plan in the resident's record. According to rule ending in 673, Sub-Rule 1, an assistive device or therapeutic support intended to achieve or maintain a resident's proper position to enhance mobility, physical comfort, safety, and well-being must be specified in the resident's assessment plan and agreed on by the resident or resident's designated representative. Any voluntary work that is performed in the home by a resident shall be in accordance with their written assessment plan. Work is defined to mean any activity which results in a benefit to the facility. Residents are not to be used to provide a source of labor for a home against their will or in opposition to the objectives of their assessment plan. Residents have the right to receive visitors at the facility at a reasonable time. Exceptions or visitor restrictions must be covered in the resident's assessment plan. If a resident requires behavior interventions, the licensee shall ensure the methods of behavior intervention are appropriate to the needs of the resident. Interventions must be specified in the resident's assessment plan and performed in accordance with that plan. Interventions must ensure that the safety, welfare, and rights of the resident are adequately protected. If an intervention is needed to address the unique programmatic needs of a resident, the intervention must be developed in consultation with, or obtained from, a professional or professionals licensed, certified, or registered in that scope of practice. Staff responsible for implementing a resident's assessment plan must be trained in the applicable behavior intervention techniques and on-site at the facility during each shift. According to rule ending in 651, Sub-Rule 1, commonly used areas of the facility must be accessible to all residents unless a resident has restrictions imposed in their assessment plan or individual plan of service. Rule ending in 653 indicates that resident-occupied rooms must be heated at no less than 68 degrees Fahrenheit. While air conditioning is not required, precautions must be taken to prevent prolonged resident exposure to non-circulating air that is at a temperature of 90 degrees Fahrenheit or above. Any variations to this rule must be based on a resident's healthcare appraisal and addressed in their assessment plan. According to rule ending in 661, Sub-Rule 2, the bed and mattress requirement as indicated in Sub-Rule 1 of this rule, can be removed from a resident if the resident or resident representative requests that it be removed, the resident's healthcare professional approves an alternative sleeping arrangement, and it is documented in the assessment plan. There are several common problems and potential violations associated with resident assessment plans. One of those problems being that upon inspection, the licensing consultant determined written assessment plans were not filled out completely. There are often missing dates and signatures from the individual completing the assessment, the resident and/or their representative, responsible agencies if applicable, and the licensee or licensee designee. It is not uncommon for facilities to use their own written assessment tool, and that tool does not include all the required elements of a written assessment plan. There are occasions when assessment plans are not updated as needed, to accurately reflect the type of supervision, protection, and personal care a resident requires. Occasionally, it may be determined that the assessment plan identifies the resident's needs but does not identify how licensees and/or direct care staff will address those needs. Let's turn our attention to the resident care agreement. A resident care agreement is a document established between the resident or his or her designated representative and responsible agency, if applicable. Resident care agreements specify the responsibility of each party. According to rule ending in 685, Sub-Rule 6, a licensee shall complete a written resident care agreement at the time of a resident's admission. A licensee shall use the Department Resident Care Agreement form, or a facility substitute form that includes the same information as the department form. A resident care agreement must include a statement that the facility is licensed to provide foster care to adults, the services to be provided and the fee for those services, any additional costs in addition to the basic fee that is charged, a resident's rights policy, a discharge policy, transportation services provided for a basic fee and services that are provided at an extra cost, a refund policy, a resident's funds and valuables policy, an agreement by the licensee to provide care, supervision, and protection to the resident and to ensure transportation services as indicated in the resident's assessment plan and resident care agreement, an agreement by the licensee to respect and safeguard the resident's rights, an agreement by the licensee and resident or the resident's designated representative to follow the facility's discharge policy, an agreement by the resident's designated representative, or responsible agency to provide necessary intake information, including health-related information, at the time of admission. An agreement by the resident or the resident's designated representative to provide a current healthcare appraisal. And an agreement by the resident to follow Rittenhouse rules if any. A resident care agreement must be signed by all applicable parties. A copy of the signed resident care agreement along with copies of the policies listed in Sub-Rule 6 of this rule must be provided to the resident or the resident's designated representative and maintained in the resident's record. A licensee shall review the written resident care agreement with the resident's designated representative, or responsible agency at least annually or more often if necessary. Any changes to the resident care agreement must be re-signed by all applicable parties. If the annual review results in no changes to the resident care agreement, the resident care agreement does not need to be re-signed. However, the licensee must document that all applicable parties were contacted and agreed that no changes were necessary. According to rule ending in 633, Sub-Rule 1, a licensee shall always have sufficient direct care staff on duty for the supervision, personal care, and protection of residents and to provide the services specified in a residence assessment plan, health care appraisal, and resident care agreement. Next, we will move on to required resident records and documentation pertaining to the handling of resident funds and valuables in an AFC home. A licensee may accept resident funds and valuables to be held in trust on request from a resident or a resident's designated representative. Resident funds means paper currency, coins, gift cards, securities, bonds, stocks, debit cards, credit cards, and other like funds received by a licensee from, or on behalf of, a resident. Resident funds or valuables that have been accepted for safekeeping must be treated as a trust obligation. Administrative licensing rule ending in 637, Sub-Rule 3, indicates that a licensee shall have a record of resident valuables for each resident that includes a written description of the items, the date received, and the date returned to the resident or the resident's designated representative. The record must be signed at the time of receipt and return by the facility and the resident or the resident's designated representative. According to rule ending in 637, Sub-Rule 4, a licensee shall record in the resident record or resident funds and itemized transactions, including payment for services provided for each resident. Residents shall have access to and use of their resident funds in reasonable amounts, including immediate access to not less than $40. A resident shall receive up to the full amount of resident funds at a time designated by the resident, but not more than 5 days after the request for the resident funds. Exceptions must be subject to the provisions of the residence assessment plan. A licensee or administrator shall obtain prior written approval from a resident or a resident's designated representative before charges are made to a resident's account. Charges against a resident's account must not exceed the agreed price for the services rendered and goods furnished or made available by the facility to the resident. A resident fund transaction over the amount specified in the resident care agreement must require the signature of the resident or resident's designated representative and the licensee or administrator. A licensee shall provide a complete accounting on an annual basis and on request of all resident funds and valuables that are held in trust or that are paid to the facility, a resident, or a resident's designated representative. An accounting of a resident's funds and valuables that are held in trust or are paid to the facility must also be provided, on the resident's or the resident's designated representative's request, not more than 5 business days after the request and at the time of the resident's discharge from the facility. A licensee shall have a written refund agreement with a resident or a resident's designated representative. The agreement must state under what conditions a refund of the unused portion of the monthly charge that is paid to the facility is returned to the resident or resident's designated representative. A refund agreement must provide for refunds to a resident or the resident's designated representative under any of the following conditions: a resident's emergency discharge from the facility, a resident has been determined to be at risk or victim of abuse, neglect, or exploitation, or a resident relocates on a determination the resident is at risk, due to substantial noncompliance with the Act or these rules that results in the department taking action to issue a provisional license, revoke, summarily suspend, or refuse to renew a license. Personal property and belongings that are left at the facility after the discharge or death of a resident must be inventoried and stored by the licensee. A licensee shall notify, in writing, the resident's designated representative of the existence of the property and belongings and request disposition. Personal property and belongings that remain unclaimed, or for which arrangements have not been made, may be disposed of by the facility after 30 or more days from the date that written notification is sent. Next, let's discuss incident notifications and incident reports. If a resident has a representative identified in writing on the residence care agreement, a licensee shall report to the resident's representative within 48 hours after any of the following: unexpected or unnatural death of a resident, unexpected and preventable inpatient hospital admission, physical hostility, self-inflicted harm, or harm to others resulting in injury that requires outside medical attention or law enforcement involvement, a natural disaster or fire that results in evacuation of residents or discontinuation of services greater than 24 hours, and/or elopement from the facility if the resident's location is unknown. An incident must be recorded on a department-approved form, or a facility form that contains the same information, and retained in the facility for 2 years. The department may review incident reports during a renewal inspection or special investigation. This does not prohibit the department from requesting an incident report if determined necessary by the department. If the department requests an incident report, the licensee shall provide the report in electronic form within 24 hours after the request. The department shall maintain and protect these documents in accordance with state and federal laws, including privacy laws. Licensing consultants will review all accident and incident reports during inspections and investigations. Licensing consultants will review recent hospitalizations as a result of an individual incident or accident. Licensing consultants will also note any failure on the facility's part to provide protective supervision and note any documented physical plant problems that may have contributed to an accident or incident. Moving on to resident weight records. A licensee shall record the weight of a resident upon admission and monthly thereafter. During inspections and investigations, the consultant will review weight records for significant weight losses and gains, and follow up with licensees as needed. Let's discuss required documentation regarding resident grievances. If there are any written resident grievances, the grievances must include the nature of the grievance, and a statement indicating how the grievance was addressed. Licensees are required to obtain all written statements and instructions for supervising prescribed medication to residents, including dietary supplements and medical procedures. Licensees are also required to complete and maintain an individual monthly medication log, containing the names of medications, the dosage, the label instructions for use, the time to be administered, the initials of the individual who administered the medication at the time given, and any resident's refusal to accept prescribed medication or procedures at the time of refusal. Let's discuss instructions for resident emergency care and advanced medical directives. If a resident has any of these items, the licensee must have them immediately accessible if a crisis occurs. Subsequently, these items should be maintained in the resident's record. A Do Not Resuscitate Order, otherwise known as a DNR, is a common type of advanced directive. A DNR is a legal medical order that instructs individuals, including AFC staff members, not to perform CPR if the resident stops breathing or their heart stops. Licensees are required to inform their staff of all advanced directives, such as DNRs, and to include them in residents' assessment plans. Let's discuss required resident documentation pertaining to a resident's discharge. A licensee shall provide a resident and resident's designated representative with a 30-day written notice before discharge from the facility. The notice must state the reasons for discharge, and a copy of it be sent to the resident's designated representative and responsible agency. The provisions of this sub-rule do not preclude a licensee from providing other legal notice as required by law. The licensee may discharge a resident before the 30-day notice when specific criteria are met, as indicated in Administrative Licensing Rule ending in 687 Sub-Rule 5. A licensee must notify the resident's designated representative, the resident's responsible agency, and their assigned adult foster care licensing consultant not less than 24 hours before discharging the resident. The emergency written discharge notice must include the reason for discharge, including the specific nature of the risk, the alternatives to discharge that have been attempted by the facility, and the location where the resident will be discharged, if known. Licensees must maintain all copies of resident discharge notices on file in the facility. Let's discuss the individual resident record. A licensee shall complete and maintain a separate record for each resident that includes personal information including all of the following: resident's full name, social security number, date of birth, marital status, veteran status, gender identity, former address, name, address, and contact information of identified contact or designated representative. Name, address, and contact information of the person and agency responsible for the resident's placement in the facility. Funeral provisions, preferences, and contact information. And resident's religious preference. The resident record must also include the resident's date of admission, date of discharge, and address to where the resident moved, all healthcare information, including healthcare appraisals, medication administration record, the name, address, and contact information of the resident's preferred healthcare professional and hospital, their medical insurance, and all statements and instructions for supervising prescribed medication, including dietary supplements and medical procedures. As mentioned earlier, the resident record should contain any instructions for emergency care and advanced medical directives. Lastly, the individual resident record must include all copies of the resident's care agreement and assessment plan. It must include the resident's admission and monthly weight record, and written incident reports pertaining to the resident's funds and valuables record and resident refund agreement, as well as any written resident grievances or discharge notices, if applicable. Resident records must be kept on file, in the facility, for 2 years after the date of a resident's discharge, unless a shorter retention is specified elsewhere in licensing rules. This concludes our video training on required resident forms, documentation, and records in adult foster care homes. We hope to see you at the next video training series on adult foster care licensing.